Ladies and gentlemen, welcome to this episode of the BUL Emerging Law Voices. Here at the BUL campus, we have the pleasure today to be hosting an important voice in public law, in constitutional law in particular, Dr. Craig Prescott, lecturer in the Royal Holloway, University of London. Craig, we know each other, and I'm very happy to host you here at BUL. And we're going to have a discussion about public law, constitutional law, but also the more doctrinal and more also ideological themes around the particular field of law. So we're talking about constitutional law here in the United Kingdom, but the United Kingdom doesn't have a written constitution. Do you think that's an antithesis? That's a kind of something that has to be tackled?
It certainly makes constitutional law quite unique here in the UK in that it is, a mixture of different sources. Not all of those sources are legal. So a peculiar thing about being a constitutional lawyer is that you spend a lot of your time not looking at law. You spend your time looking at what we call constitutional conventions, political rules, as well as, of course, the legal sources, Acts of Parliament, case law, and what have you. And of course, it's a historical constitution. And so you can spend your time, I sometimes wonder, am I a historian or a lawyer? Or a political scientist, or whatever. As a constitutional lawyer, you are lots of different things.
Do you think that the fact that the Constitution is not written makes it more volatile to political pressures?
Certainly you might think that given what's happened over the past 25 years, where we've had an enormous amount of constitutional change. We've had devolution, the enactment of the Human Rights Act, the House of Lords Act 1999, which removed all but 92 of the hereditary peers from the Lords, which that business has now been completed as of last week when the remaining hereditary peers went. And then we, of course, have had Brexit. And so, it is a political constitution that if politics decide to embark on a constitutional change, then in principle it can happen. We don't have an entrenched constitution that can make changing it more difficult. All that's needed in principle is a majority vote in the Commons and the Lords, and it happens.
So how do we avoid manipulation by the political system?
So there are, in a sense, some safeguards. You have, firstly, the idea that most governments will want to get re-elected the following time. So there's political accountability. There is then the role of the House of Lords, which can be a check on the Commons. And perhaps we saw this with the assisted dying legislation over the past few months, where, yes, it got approved by the House of Commons. Many people had concerns about the bill, and particularly it was passed as a private member's bill, which meant that the normal processes that go behind a bill weren't followed, and it didn't get through the House of Lords. So, we do have examples of where there are some checks on the power of the Commons. And we've seen in certainly some situations, the prorogation crisis, where the court stepped in. So there are sort of checks along the way. And something else that I think sometimes can be overlooked is the role of the media. That, if a government is embarked on what could be an outrageous course of action, then they could be pilloried in the media for it. And our politics is very responsive.
But the problem with the media is that the government, the politicians will accuse the media of manipulating the crowds and having a certain political stance. And the media, of course, will say that they're doing the job. So it's a vicious circle. And then in cases where we have a strong constitution, maybe, then the constitutional rule, the legal rule is there in order to guide the rules of the game.
Perhaps, but that didn't necessarily work out so well in America with President Trump, where you have rules, but he at times does not play by them. And there you have a media where very partisan, and President Trump very much goes after those who he sees not on his side. In the UK, I think it's all a little bit more subtle than that. That you do see papers that historically support the right-wing parties, the Conservative Party, having a good go at them from time to time when they do things that they don't necessarily approve of or feel their readers won't approve of it. It's sort of like so much in the British Constitution, it could be shades of grey as much as anything, and I do think that role of the media can be very important, and we do have the BBC as well, which has that sort of commitment to impartiality that should ensure that you get information out to the broader population. It is the biggest media brand in the country. But of course now you have social media, you have YouTube, and I think that is a big area of our political discourse, and I think perhaps how politics hasn't yet got to grip with the new media environment. And I think, that might be some of, say, Keir Starmer's troubles, where we're recording this on the day after the local elections. Labour hasn't seemed to have done very well, and votes are leaking to the Greens and to Reform, who are much more social media friendly. So that, I think, is a big question for the next 5 years or so, is how politics gets to grip with that.
Craig spoke now in the aftermath of the local elections, as you mentioned, and I want to ask you again, speaking about staying in the kind of framework of the written constitution, the relationship between the central government and the local authorities. In some constitutions we have it entrenched, meaning the central government has to allocate certain funds to the local authorities. This is not the case, particularly here in the United Kingdom. Do you think that the constitutional rule would actually help towards this direction?
So you're absolutely right that in the UK there's no constitutional guarantee for central government. And most people would say a big problem with central government is that it's mandated. With local government, is that central government tells it to do this, this and this, and they have to do that by law, and those legally mandated functions are taking up a greater share of the income of local authorities, and there's less to do elsewhere, particularly social care, special educational needs, and so on, taking up a bigger and bigger chunk of local authorities' budgets. And in some ways, with austerity, local authority budgets were cut as a way of achieving cuts to government expenditure, but in a sense you blame the local authority for that, not central government imposing the cuts. So there is a sense that local government is a bit of a plaything of central government. Local government is a mess in this country, particularly in England. You have a patchwork of two-tier authorities, unitary authorities, overlapping responsibilities. I know when I lived in the northwest of England, in Chester, I had a unitary authority, which was Cheshire West and Chester. I had a police and crime commissioner, which was all of Cheshire. But the fire service covered a different geographical area, and it was Northwest Ambulance that covered a broader, so you have lots of different functions that local government or central government do, but there's just a total mess, a patchwork of overlapping responsibilities. So, in some ways, I'm quite a big fan of regionalism and having regional government. Which was tried, there was a referendum in the northeast for a regional assembly. It didn't go down very well.
But also this regional government is not going to be part of a constitutional game.
Well, that's the thing, is that, in terms of creating this, you need to demarcate properly what a regional government does, what central government does. The problem in the UK is always what are those different levels, and what are the boundaries of these regional governments.
And how much rigid we want it to be, because we want to be more rigid, then we aspire to be more constitutional kind of status norm, rather than just a norm that can be maybe deemed to belong to the ordinary legislation. But the thing is, as you said before, In the United Kingdom, the constitution can be amended very easily with a majority vote. So the question is, what's the difference between a constitutional norm here in the UK vis-à-vis an ordinary legislation norm, if both can be amended by a majority rule?
That's very true. There's certainly a sense that some constitutional statutes have more weight. The devolution legislation, for example, has more weight. It would be difficult to imagine the House of Commons just turning around saying, we're going to abolish Scottish and Welsh and Northern Irish devolution. Indeed, Northern Ireland is itself in a particular situation because of a treaty with the UK and Northern Ireland, the Good Friday Agreement.
Can I ask you here, but put a semicolon on this? So the question is, what makes the difference to the consciousness of the legislative body that certain norms, certain acts of legislation can be surpassed and abolished and amended, and certain cannot be tackled so easily because they have a kind of a constitutional status? Is it a metaphysical attribute to the norm?
I would say so. It's the political weight. It's the, it's fundamentally driven by the politics and, I would say, particular political priorities at any one time. A government coming into Westminster may not like Scottish and Welsh devolution. If we look 5 years ahead, perfectly possible. But would abolishing devolution be a political priority? And I think the answer would be no. There's many more pressing priorities for any government sort of coming in. And so there's as with so much, it's politics. It's sort of, that's what drives it. A lack of initiative or need to deal with that particular issue, but also as well, some like Scottish, Welsh parliaments are both very well established now, particularly the Scottish Parliament, and a government embarking on abolishing that would come up against a wall of criticism, no doubt from Scotland, and then you're making the argument for Scottish independence for the SNP. And if you're a unionist party, you wouldn't do that. So, all these things are overlapping.
Craig, you mentioned before the role of the courts also in this kind of conundrum between the government, the legislation, the Westminster. My question is, in a country like the United Kingdom that doesn't have a written constitution, doesn't this mean that courts are meant to become more judicially activist? And if that's the case, why haven't we seen so far the UK Supreme Court being the epitome of activism?
Well, some might say it has been. If you look at the two Miller cases, there was an argument from some politicians and public law scholars that said the Supreme Court perhaps had overreached itself.
But stop there. Whereas we have the US Supreme Court, in other countries' Supreme Courts, all the time they have got the fame that in essence there are too much activist courts. The UK Supreme Court doesn't have such a name so far.
Yes, but of course that is because it's not a constitutional court as such. It does not, political disputes generally don't end up there. Whereas in America, we've seen this with the tariffs. That if there's something that is politically controversial, you could reasonably expect it might end up in the court to determine whether the action of the president was constitutional or not. So that brings the Supreme Court into play much more, and it brings the question of appointments to the Supreme Court into play, much, much more. Whereas in the UK sort of constitution and for the UK Supreme Court, it's different. They are. It's not sort of deciding political questions in that same way. Occasionally, questions do get thrown up and end up in the Supreme Court, But they are, as Lady Hale was very sort of plain to say, they're not deciding political questions, they're deciding underlying legal questions, and it is for politicians to deal with those consequences. And that's not a new development in the UK Constitution. We can go back to the case of proclamations and of 1611 and so on. That, you know, this is something that does happen from time to time, but in principle that's not the Supreme Court's main role by any stretch of the imagination.
So you said the UK Supreme Court, when it comes to the stability of disputes, differs itself from the US Supreme Court regarding the political question doctrine and how much it goes to it.
Yes, it will interpret questions given to it in terms of law, not politics, and will.
But you say something goes so much deeper. The society itself, maybe the system doesn't actually apply, doesn't send highly political questions to the UK Supreme Court. Maybe in advance, they know the UK Supreme Court is not going to necessarily give an answer.
Yes, that's very true, because we have this sort of concept of parliamentary sovereignty. So, you know, if politicians want to do something, they can.
Which maybe is, again, another metaphysical concept, meaning we have a concept also in law, but maybe somebody could say, despite the concept, somebody would like to petition the UK Supreme Court to alter something that the Parliament has put forth.
Perhaps, but the Supreme Court would not alter what Parliament has said, because it will just interpret and apply the legislation. So it won't strike it down, unlike America. So there's less value in going to court in that way. And that if you want to change the position, you do it through Parliament. You know, in a sense, that's the difference. And you might say the first Miller case was one of the most pointless cases in legal history, because what it did was not, I think some people may have crowdfunded it on the basis that it might have stopped Brexit or something, but if you remember, the question was, how could Article 50 be triggered? Should it be done under the royal prerogative, or was legislation required? And Theresa May wanted to do it under the royal prerogative. Campaign sort of thought that was outrageous, and then it went to the Supreme Court and they said legislation was required. And then one of the shortest acts of Parliament in history was passed, giving Theresa May the totally unfettered power to trigger Article 50. So you ended up in the position that you would have been in had it been the prerogative. And so what was the substantive outcome for those people who brought that case, the Gina Millers of this world? I really struggle to see it. I think they may have made political assumptions that Parliament might have imposed conditions on how Article 50 could be triggered or something. Maybe the House of Lords might have put some amendments into the legislation. I don't know, but that proved, if that assumption was made, that was a spectacularly wrong assumption to make.
And Craig, inside this whole debate, we have also the role of the monarchy, the role of the palace, as a unifying factor. This at least should be the role of the monarchy, and traditionally is the role of the monarchy, at least in this country. But of course, we have also the monarchy in crisis the last a few months, let's put it like this. And of course, it's also Prince William himself who has raised doubts whether he will be the head of the Commonwealth in the future. So the question is, how much do you see the monarchy surviving the current crisis, and how much do you see maybe the monarchy changing a bit its role and nature in the future?
Okay, there's an awful lot in there. So that's so in terms of the monarchy surviving, I think generally it's pretty safe. I think the remarkable thing about one sort of remarkable fact about polling in British politics is how stable support for the monarchy is, or how stable it all is. It's been on a long, slow decline from a high point of around 75% in 2012 to now around 65%, maybe a little bit lower on some polls. But there doesn't seem to be particular troughs when a scandal emerges. And Mexit and Andrew Mountbatten Windsor, as we call him now, has not really dented support for the monarchy as such. And I think we've seen a new style with the king compared to his mother. I think we saw that in the state visit last week in America, where I think you saw a king going about his role in a way that Elizabeth II never would have done. It was his speeches before Congress and the White House were more political. They definitely addressed certain elephants in the room, given the relationship between the US and the UK. And they didn't require much decoding. Many of Elizabeth II's speeches were very often written in like a sort of code, and you needed to do a course in Windsorology to decipher the code sometimes. You didn't need to do that last week. And also how funny he was. And so that was a very different style, and I think that's how the monarchy renews itself, that each monarch does do the job differently within the parameters of the constitution and the role itself. Then as regards changing in the future, Prince William has talked about this, that when he becomes king, things will be different. There's lots of sort of commentators out there saying, yes, the monarchy needs to change, the monarchy needs to be different. There's always rather less detail on what that change actually means. And I think you can see some changes already happening. We're having a much smaller royal family. Some of that is by accident because of Prince Harry and Andrew, but some of that is by design. That the children of the Duke and Duchess of Edinburgh won't do royal duties. Beatrice and Eugenie don't either. And if you fast forward 10 years, you might be looking at a much smaller royal family that is just Prince William and the Princess of Wales, and perhaps as King and Queen and their children. You might still have Edward and Sophie, the Duke and Duchess of Edinburgh, as well, but you might not have Princess Anne, you might not have the King and Queen doing duties. So, and there's no evidence that like in terms of number of people, that they will be replaced.
And when it comes to the Commonwealth, and I'm speaking now about the big countries belonging to the Commonwealth, meaning Canada and Australia, do you see them staying in the Commonwealth or under the Crown?
So I think there's a distinction to be made between membership of the Commonwealth, which is, if my memory is right, 54 countries, and some of those don't have the king as head of state. Indeed, there's 15 nations that have the king as head of state. And so I think there's an open question as to whether Canada and Australia, New Zealand and others will continue to have the king as their head of state, but they would still remain a member of the Commonwealth. So these Commonwealth realms, clearly because for historical reasons, they've decided to keep the British monarch as their head of state. And you could see why in the 1930s, when the dominions were becoming more self-governing, that the link with the crown was a link to the mother country for many people in Australia and so on. Of course, once you get 100 years later, and they are, to all intents and purposes now, their own state, a fully fledged independent state, it does become an increasing oddity for Australia to have effectively a British citizen living thousands of miles away as their head of state. It's a perfectly rational argument saying Australian should be head of state to Australia. So you could see that argument coming at some point, but there's just always the question of right time. When is the moment to really make that change? Some thought that this would have been when Queen Elizabeth died and we moved to Charles III. It didn't materialise. And what you did see in Canada last year was the King delivering the speech from the throne in person. And that was an assertion of Canadian sovereignty in the face of threats from Trump over Canada being the 51st state or something. And it made the point that Canada was different and that Canada had its own political traditions and that sovereignty laid somewhere else. And it wasn't with the President of the United States and never would be. And so that was, that showed you the value perhaps of having a monarchy if you're a country like Canada, because it's something different. And it reflects that Canada has a very different history to the US and is not just some sort of adjunct or annex of the United States. So, you know, events play out very oddly sometimes.
Craig, thank you very much for this interview. Indeed, it was a very elucidating interview and discussion we had. We're going to close the discussion here. Ladies and gentlemen, we hope you also enjoyed this discussion with Craig Prescott from the Royal Holloway University of London.